Davidson at Albertson & Davidson. In this video, I'm going to show you how to fill out a petition for probate. This is form DE-111. And a number of years ago, I actually did a video explaining how to fill out a petition for probate. But since that time, the form has actually changed quite a bit. They've made a lot of updates to the form, and they changed around the information that you have to include on the form. So in this video, we'll walk through the current form as it currently exists, and we'll see how to properly fill out a petition for probate. So if you're going to open a probate estate for somebody, either because they died with a will and you need to transfer some property under the will, or they died without a will and you have to do an intestate estate, this is the form that you're going to need to start the process. So as with all of our forms in our Form Vault series, I always start just by going to Google. And that's what I did here. And you just search for judicial council forms. You can go to the California Court's website and you're going to click on probate forms, decedents estates. And I happen to know that we need DE-111. It's the first form up on the page here. If I didn't know that, I could do a search here by name or by form number. So I've brought up the form right here. Now this form looks like it'd be fairly easy. It's a pre-printed form. There's just a few boxes you have to check and you can file it with the court and you're off to the races. The problem is the form is more complicated than it appears. And if you check the wrong box or if you fail to check a box that you're supposed to check, you're going to have a lot of problems. Your petition is going to be rejected by the court and you're going to have to go back and start from square one. So it really pays to take a little bit of time to really understand what you're doing here and do it properly. So we start off at the top by putting in your name. So I'm just going to put my name in here. If I were representing myself in this lawsuit, then you just put your own name. Since I'm a lawyer, I'm going to put my law firm information in there as well. And of course, I have a state bar number that goes there. If you don't have a state bar number, then you can just leave that area blank. And then we're going to put in the address that we want to use for purposes of the court. We have 5 offices in California, but I'm going to use the Carlsbad address where I spend a lot of my time. 92008. All right, and you want to make sure you have your phone number on here because the court may need to contact you at some point throughout the process. And whatever information you put up here, when you file it with the court, that's going to be the information that the court's going to use from now on to try to contact you if they need to contact you. And that's why you also want to make sure that you have your email in here so the court can contact you if need be. And then you're going to put attorney for. If I were doing this on my own, I'm just representing myself, you can type pro per in here. Or you can just type your own name in here. And that way the court knows that you're just representing yourself. But since I'm an attorney, I'm going to say that I'm representing Bob Smith in this probate estate. And we're going to have to list next the county that we're filing this in. So let's say it's Los Angeles County. And the street address is 111 North Hill Street. That's the physical court address that you put in there. And then under mailing address, you need to put in the court's mailing address. In this case, they're the same, but that may not always be the case. And then you put in the city and the zip code. I don't remember the zip code for Los Angeles, but you can look it up. And then you put in the branch name for the court. If you don't know the branch name, you can go to the court website and look it up. And if you can't find it there, you can leave the branch name blank when you file it. This is going to be the estate of, and we'll put in Bob's wife, Rachel Smith. And so that's what this estate is for. Now, right off the bat, this section here where it says petition for, this is going to be a very confusing section if you don't understand these terms. So you really have to pay attention here. So this is a petition for, and the form wants to know, are you filing a petition for probate of a will and for letters testamentary? Are you doing a probate of a will and for letters of administration with will annexed? Are you looking for letters of administration, letters of special administration with general powers, authorization to administer under the Independent Administration of Estates Act? Do you have a lost will? There's a lot going on here. So the first question is, do you have a will? If so, then you're probably going to be checking one of these two boxes. So let's check that one for probate of a will. Is the original will lost? I hope not. That causes problems if you lose the original will. The original will has to be lodged with the court. And if you lose that original will, the law presumes that the will was lost with the intent to revoke it. So if that original will isn't around when Rachel Smith passes away, then the law presumes the will was revoked. You can overcome that presumption, but you have to show facts to overcome it. And that's why the form wants to know, do you have a lost will or do you not? And then this form is asking, are you going to petition for probate of a will and for letters testamentary? The only difference between letters testamentary and letters of administration with will annexed is whether or not the person who you want to act as the personal representative is named in the will. If a person is named in the will, they're the executor. And as the executor, you're asking for letters testamentary. So you just check this first box. If the person who you want to act as personal representative is not named in the will, but there is a will, then you'll check the second box. Then what you're asking for is you want to admit a will to probate, and you want what we call letters of administration with will annexed, which is just a very confusing way of saying that the person who's going to act over this estate isn't named in the will. If you don't have a will, it's just an intestate estate, then you're going to go with letters of administration. You're not asking that the court admit a will to probate because there is no will. You just need letters of administration for somebody to manage the estate. Letters of special administration is for emergencies. If you need somebody appointed on an emergency basis in order to handle some asset in the estate that's in danger of being lost, then you would do that, in which case you would not click the letters of administration. But we're going to say we're doing a will and for letters testamentary because we're going to say Bob Smith was named in that will to act as executor. And then down here, the authorization to administer the estate under the Independent Administration of Estate Acts. We're going to talk about that more later, but we do want to click that. You almost always want to ask for that if you can get it. The case number and hearing date and time and department we're going to leave blank because the court's going to fill that in for us when we file this with the court, so we don't have to know that. Publication will be, so you're going to have to publish notice of your probate in a newspaper. Otherwise, it can't be granted. It can't even be heard. So you have to tell the court where you're going to publish it. So you put whatever newspaper you're going to use right there. And either you tell the court, I've already requested publication, or it's going to be arranged. I'll get around to doing this after I file the petition, which is normally what we do. So we start here with the petitioner. Who is bringing this? Again, that was Bob Smith. He is the petitioner. He's the one who's filing this and asking that the court take whatever action is included in this petition. And he's requesting that decedent's will and codicil, if any, be admitted to probate, and whoever the named executor is. So we're going to say that Bob Smith is the named executor. We'll type his name in there, and he's going to be the executor. Now you'll see that there's these different terms once again down here. There's executor, there's administrator with will annexed, and there's administrator. An executor is somebody who's named in the will to act. So if Bob Smith is named in the will, then he's an executor. If there's a will, but Bob Smith is not named in that will, somebody else is, but that whoever that is, they don't want to act, so Bob's going to do it instead, then that would be an administrator with will annexed. That's just a complicated way to say that Bob Smith isn't named in the will, but he's going to act over the will in any event. And then an administrator just means that there is no will. So if there's no will, it's just an intestate estate, you're going to be an administrator. Here we have an executor. Special administrator, again, is for emergency powers, so we're not going to do that. Here we get back to the Independent Administration of Estates Act. There's a lot going on with this act, and if you really want to look it up, go to Probate Code section 10,400 and start looking through there. There's all sorts of powers that an executor can be granted, where they can do certain things without court approval, such as selling real property, compromising on debts, all that sort of thing. So we almost always want to ask for full power so we can do as much as possible outside of court if we can. There's still things that the executor can't do outside of court. They can't pay themselves, they can't pay their lawyer, and they can't close the estate and distribute the assets out to the beneficiaries by themselves. All of that still requires court approval, even if you have full powers. But we're going to ask for full powers. Next is a bond. So a bond is kind of like an insurance policy that ensures that the executor doesn't steal any money from the estate. And if the executor does steal money from the estate, then the beneficiaries can be paid back that money from the bonding company. For that reason, you almost always want your executor to have a bond because it's just safe. It's safer for the beneficiaries. But a lot of wills will waive bond because they don't want the estate to have to pay for the cost of that bond. Although, quite frankly, most bonds are not that expensive, especially considering the protection that you receive for them. But if your will waives bond, then you would check there. There's a few other times when a bond's going to be waived, and we'll talk about that when we get down to 3E. If you're not going to waive bond, then you're going to click here and you're going to say, this is what I want bond to be fixed at, and the bond will be furnished by an admitted surety insurer or as otherwise provided by law. And so there's insurance companies that are licensed to be able to provide these bonds. And you're going to put the amount of the bond, and the amount of the bond is based on the amount of the estate that's liquid. So if there's $100,000 worth of cash here, you're going to want a bond of at least $100,000, and a lot of times you'll end up with the bond a little higher, 20% higher, $120,000, something like that. So whatever bond you want, you'd specify that. You can also ask that the estate accounts be put into a blocked account. That's a little more difficult. Blocked accounts are very hard to deal with, but in certain cases that might be appropriate. So we're going to say that the will waives bond, but this is where you would fill in the bond. Here you would put in when the decedent died, and so the court needs to know when the person passed away. So we'll say October 1st, 2018, and they need to know the place where they passed away because that's going to be important as to where the proper place to bring your petition is, because the decedent has to have been a resident in the county named above in order for you to bring your petition. So if I'm going to file this petition in Los Angeles County, then that has to be the county where the decedent resided at the time of their death. If it isn't, then you shouldn't be filing this in Los Angeles. If they resided in San Mateo County, then that's where you should file this, not Los Angeles. The other alternative is if you have somebody who resides outside of California, but they left some real property in the state of California, then you would file this in the county where the property was located. But most of the time, you're going to be under 3A1, a resident of the county. And then right here, decedent was a citizen of a country other than the United States. If that's the case, then you would click this and you would fill in the state or the country where they're a citizen. And now the court under C wants to know, well, what was the address of the decedent at the time of death? And so this is where you would fill in whatever their address was so that the court can see that they are, in fact, a resident of that county where you're filing this petition. Moving on to the second page, we now are going to fill in some very basic information about the value of the property. A lot of times people get a little concerned about filling this in because they think, well, I don't really know what the property is worth. I don't know how much the property will appraise for. This doesn't have to be exact. You're going to do an inventory and appraisal once the estate is open. This is just to kind of get the ball rolling, to get everybody an idea of how much property there might be in this estate, especially the creditors, because a lot of creditors want to know, can I collect from this estate? So you'll just fill in the appropriate information. You can, for real property, for example, you can go to Zillow, get some values, and just fill it in as best you can. And then you'll total it down here at the bottom. Now we get back to 3E. Remember when we had that question about whether or not bond was going to be waived? Under 3E, the court wants to know why bond is waived. So it could be that the will waives the bond. So the will might say you don't have to get a bond. It could be that you're a special administrator and under the will, it waives the bond. Or under 2, it could be that all beneficiaries are adults and they have waived the bond in writing. You have to actually get separate waivers from every single beneficiary in order to qualify for this. And if I were a beneficiary of an estate, I would not sign one of these. But that's up to you. Everybody is different. So you should look into that. or all heirs at law are adults and have waived bond. It's the same thing. It's just that heirs are people who are receiving without a will. It's the same as two, except in cases where there's no will. So, and number 4 is if the sole personal representative is a corporate fiduciary or an exempt government agency. So if the county is going to be the one who acts as the executor, they don't need a bond by law. They don't have to do that. Now we're going to go on F. So you're going to say either decedent died intestate, which means that the decedent didn't have a will, or you're going to say here's a copy of the decedent's will dated on whatever date that the will was dated. So let's say the will is from January 1st, 2005. That's when it was created. If you have an amendment to the will, which we call a codicil, you'll click right here. And that way you'll have exactly what you need. And you'll attach a copy. The wills and all codicils will be attached to this petition. The court also wants to know if the wills and all codicils are self-proving. And you can go to Probate Code section 8220, and you'll see what that means. There's some language that a will has to have at the end in order for it to be a self-proving will. If it is a self-proving will, it makes your job a lot easier because you don't have to hunt down those witnesses when you file this petition. You just file the will and you're good to go. If it's not a self-proving will, then you got to find the witnesses and have them sign a form. And that can be a real pain because sometimes it's hard to find these witnesses many years later. So most wills are self-proving, and you would check that box. And then 3 is if you lost the original will. So if you have the original will, that should be lodged with the court. And there's an actual form. You just take it down to the courthouse and they keep it forever and ever. If you've lost it, or if it can't be found at the time of the decedent's death, then you've got a problem because there's a presumption that the will was lost with the intent to revoke it. And you don't want that. You can overcome that presumption, but it's not particularly easy. So you want to try and get rid of that. Hopefully you don't have a lost will, but if you do, you need to check this box and you need to put an attachment explaining what happened to the will and why the lost will presumption should not apply to you. Next, we're going to get to the appointment of personal representative. So this is where the proposed executor is named as executor in the will. So if that's the case, you just go ahead and click that. It could be that there's no executor named in the will. That's why somebody needs to be administrator with will annexed. It could be that somebody's a nominee. The court under D wants to know, well, why are the other named executors not acting? So maybe one of the other named executors has passed away, or they declined to act for some reason. They just don't want to do it. The court wants to know that right here. If you're an administrator, then you check one of these boxes. So this is where you have an estate without a will, and this is where the petitioner is the person entitled to letters for some reason. And there's actually a list of priority under the probate code. So the spouse has first priority, and then the children, and so on and so forth. So whoever is going to be acting as the administrator for an estate that doesn't have a will, you'd mark the box that shows why you have the right to be appointed. It's probably going to be A, most likely. Okay, now under H, the court wants to know something about this personal representative, the executor or administrator who's going to be acting. So first of all, are they a resident of California? The court prefers California residents. If they're a non-resident, then they want to know, well, what address? Where's this person's address at? Every now and again, the court will appoint a non-resident of California, but most courts really prefer that somebody resides in this state if they're going to act as executor, and they definitely want them to reside in the United States if they're going to act as an executor. Going down to the next page, number 4 asked, you have to specify that the will does not preclude administration of the estate under the Independent Administration of Estates Act. So some wills do say that you can't use that. Most of them don't, but the court wants you to say whether it does or not. Number 5 is very important. This is going to be everybody who has survived the decedent, and you're going to have to specify everyone. So, for example, was there a spouse? You have to click that. If there was no spouse, then the court wants to know, well, was it because they were divorced or never married, or the spouse was deceased? What's the situation there? In California, we have registered domestic partnerships. You have to say that, or no registered domestic partner. And then you have to say whether there was children. So there's a child. Are they natural or adopted? Natural, adopted by a third party. No child. You really have to stop and think about each of these questions when you answer them. So if you have one or more children, you can just click that box. You don't have to click any of these others. But if you have no child but issue of a predeceased child, which would be grandchildren, then you would click down here in number 7. So you really have to go through each of these and think about which one applies. And then B talks about whether or not the decedent was survived by a stepchild or foster child, because there are times when those people who are stepchildren or foster children might be able to receive a portion of the estate, especially an intestate estate, depending on the circumstances. So the court wants to know that. Under number 6, this one gets really tricky. You really have to read through 6 carefully. So you complete number 6 if the decedent was survived either by a spouse or registered domestic partner but no issue, or no spouse, no registered domestic partner or issue. That's the only time you're going to fill out number 6. So if you have somebody who has a spouse and issue, then you don't need to do number 6. It's only if you have a spouse and no issue. So it's a very confusing section. So make sure you understand what they're asking you. And the first one's going to say decedent was survived by parent or parents who are listed in item A. Essentially, the reason why the court wants to know number 6 is because there's times when somebody other than the spouse is going to be entitled to some of the estate if it passes intestate. Or there's times when these people listed under A through G of 6 might be entitled to something from the estate because there is no spouse and there is no issue. So the court wants to know this information. But be careful, because if you have a spouse and issue, meaning children of the decedent, you can just skip number 6 altogether. Just forget it. Number 7 is you complete it only if there is no spouse or issue survived the decedent. So again, the court needs to know what this information is, but only if there's no spouse or issue. And that's the only time you're going to fill out number 7. Otherwise, you can skip forward to number 8. Number 8 is where you're going to list everybody that you can think of that needs to get notice of this estate. That includes all of the heirs at law and all of the named beneficiaries under the will. So let's say that the will leaves everything to a charity, but the decedent have 5 children. Well, you have to name all 5 kids in here and the charity, because the kids are heirs at law. They may not be getting anything from the estate, but they're legal heirs of the decedent who at least need to get notice of what's going on. And so all of those have to be listed in here. And the form actually tells you, just include everybody that you've stated in items number 2, 5, 6, and 7. So 7's here, 6 is here, 5, we filled that out. And you could even go all the way up to 2, which is the people who are going to be named as executor. So just go back through the form, and for every box that you checked, make sure that everybody who meets the description of that goes here. It's going to be the spouse, the children, probably parents if there are no children, and the named beneficiaries under the will. They're all going to go here. If you don't have enough room, you can just click that box and continue it on the attachment, and then you're going to tell the court how many pages you have attached. At the very end here, you're finally going to get to the point where you can put in the name of the attorney, put in the name of the petitioner, and you can print it out and sign it. So I would put my name here, I would put my client Bob Smith here, and we both would sign this form. You also can print this form and save it so you can use it again or change it around if you have to. Now keep in mind that this form, the DE-111, is just the first step, the first form that you need in order to file to open a probate. There's other forms that you need to file along with this one, and that'll be the subject of our next Form Vault video. But for this video, this is the petition for probate form DE-111, and now you know a little something about how to fill out that form.